Well, welcome to the Attorney General's office. First of all, I want to acknowledge the folks that are standing behind me. From the State Police, of course, Colonel Manny, Captain John Alfred, Detective Corporal Anthony Commendatory, Investigator Gerard Ratigan. Also with me is Criminal Chief Stephen Danvers and the head of our Public Integrity Unit, John Moran, who are responsible at this office for handling this matter. This morning, late this morning, following a several-month investigation, the statewide grand jury returned an indictment charging Jeffrey Britt with one felony count of money laundering and one misdemeanor count of making a prohibited campaign contribution, specifically making a campaign contribution but disguising it as the contribution of someone else. As alleged in the indictment, these charges arise from Mr. Britt's conduct while working in 2016 as a paid campaign consultant to Speaker Nicholas Mattiello's campaign for re-election to the House of Representatives. As alleged in the indictment in 2016 in the Republican primary for the House seat occupied by Speaker Mattiello, Stephen Frias defeated Sean Lawton. After the primary in early October of 2016, Mr. Britt met with Ms. Lawton. At that meeting, they discussed the possibility of Ms. Lawton endorsing Speaker Mattiello in the general election and sending a mailer to the voters reflecting that endorsement. Later in October of 2016, Mr. Britt met again with Ms. Lawton, presented a mock-up for the mailer, and offered to assist Ms. Lawton with raising the money to pay for the mailer. As alleged in the indictment, Mr. Britt approached a person described in the indictment as Donor 1 and requested that Donor 1 contribute $1,000 to Ms. Lawton's campaign. Mr. Britt delivered $1,000 in cash to Donor 1 for this purpose. As alleged in the indictment, Donor 1 deposited $1,000 in cash into his personal checking account and shortly thereafter wrote a $1,000 check from that account to the campaign of Ms. Lawton. As alleged in the indictment, Ms. Lawton deposited Donor 1's $1,000 check into her campaign account, along with another $1,000 check delivered to her by Mr. Britt. Ms. Lawton subsequently provided Mr. Britt with a check drawn on her campaign account for $2,150, which was used to pay for the mailer. Ms. Lawton subsequently reported two $1,000 contributions to the Board of Elections, including listing the source of one of those contributions as Donor 1. At no time was it disclosed to the Board of Elections or in any public filing that Mr. Britt had funneled the $1,000 in cash to Ms. Lawton's campaign through Donor 1. Rhode Island's election laws exist for a reason: to ensure transparency in our elections. They exist to ensure that the public knows the true source of funds used to support political candidates. They exist to ensure that the public can judge the motivation underlying support for a particular candidate. In short, they exist to ensure the integrity of our elections. Mr. Britt, as alleged here, thwarted these goals by intentionally and unlawfully disguising the true source of the funds used to pay for Ms. Lawton's mailer endorsing Speaker Mattiello. This matter was referred to the Board of Elections to this office in 2018 with a request that this office consider whether Mr. Britt had violated certain provisions of Rhode Island's campaign finance laws. Upon taking office in January, I assigned this matter to our newly formed Public Integrity Unit and asked the State Police to work with the prosecutors assigned to that unit in this investigation. I'm grateful for their work and for their help. A review of the record before the Board of Elections regarding this matter demonstrates the challenges that the Board has in conducting effective investigations of election and campaign finance law violations. For nearly 2 years, the Board was stymied by various parties who failed to cooperate with the Board, even when the Board relied on compulsory process. Candidly, the Board did a great job to achieve what they did, given the cooperation that they received. But overall, this is a matter to me of great concern. And so accordingly, I want to assure the people of Rhode Island that this office and this administration will stand behind the Board in the review and investigation of election and campaign finance law violations. Simply ignoring the board's attempts to gain information without legally justifiable grounds will be a strong indication to this office and to me that the full investigative weight of this office should be utilized. And so with that, I'll take a few questions. This is a pending matter, and so I'll be limited in what I can say, but I'm happy to take a few questions.
Do you anticipate more charges to result from this?
Steve, I don't. When we received this matter, it was my intent to resolve this quickly, and so as quickly as possible. At the same time, to do a thorough dive into what the allegations were. I don't expect that anything else will arise from the matter that was referred to this office by the Board of Elections in 2018.
Did you find any evidence that House Speaker Mattiello knew what was going on?
Well, you've hit on the critical issue, Kathy, which is knowledge. And for this office to bring a criminal charge, we have to have admissible evidence that the person involved in the criminal misconduct knew of that misconduct. The person who knew of the misconduct, based on the evidence we have, was Mr. Britt, as alleged in the indictment, and that's the reason for this indictment today.
Can you please, I stepped out for 1 second just as you began talking. What are the specific charges against Jeff Britt, please?
Yeah, the specific charges, Kathy, are 1 count of money laundering, it's a felony count, and 1 misdemeanor count of making a prohibited campaign contribution. That is, making a contribution, but disguising it as the contribution of someone else.
And what are the penalties for this?
The penalties on the money laundering count are up to 20 years in prison, and on the misdemeanor count, it's up to a year in prison.
Could you explain the timing of this? Were there any issues with statute of limitations or other factors that influence this?
Yeah, sure. So certainly, well, there are 2 things I would say that play into my thinking about cases, Ian. The first is, I always want to go as fast as possible, irrespective of the statute, because I don't think cases get better with age. And I think, generally speaking, if you're the United States Attorney or the Attorney General, one of your obligations is to make sure that the pace of an investigation is moving in the way that you want it to, which to me means quickly. That said, obviously there are statute of limitations issues with all counts. There's a 3-year statute of limitations in connection with both of these charges, and so, we received this matter in this office, for all intents and purposes on January 1, so we knew we had to move expeditiously to get this done. But that didn't impact the existence or non-existence of a particular statute of limitations did not hinder us in doing this investigation. We did what we needed to do in the time that we had allotted.
Does Mr. Britt have a court date?
3-year statute as well?
What's that?
Did you say the felony?
Yes,
also
I believe it
3
does.
years?
I believe it does.
General, when was this case turned over to the Attorney General's office?
I believe, according to the records that I've seen, in October of 2018.
When did the statute of limitations run to? Today?
No, and I can't say that definitively because a lot of, statute of limitations analysis really turns on sort of individual events, and it may be on one event or another, and I think lawyers have spent a lot of time over the years arguing over when a statute of limitations passes, but I mean, you don't have to be a rocket scientist to know that, sometime this fall the statute would have passed.
When's the last time you had well, maybe not your time, but if anyone in your office knows, when's the last time someone was charged criminally in one of these campaign finance?
Yeah, Steve, I don't know. I will tell you that when we attempted to upload the indictment into the court system, the statute that we're charging was not in the system, so I suspect it hasn't been used frequently since we went into a electronic system. Well, the statute's been around, but the court system hasn't been there for so long.
And
Okay,
does
have you
Mr.
given
Britt have a court
immunity?
date? Is he been summoned to court?
Yes,
How's that going to work?
Yeah, he's going to be arraigned by I believe by the Superior Court in Kent County on November 1st.
He's not going to be arrested by the state police?
No, he's not going to be arrested.
Is he represented by counsel?
He is. Well, it's been reported by many of the people in this room. I believe it's Robert Clark currently.
Were you
Have
aware
you
that
gotten-
he was not in?
But don't hold me to that. I just know that from your reporting as well.
Have you given immunity to anybody to testify, and specifically to Matt Jerzyk to testify in this
Yeah,
case?
Kathy, I'm not going to get into the investigative steps that we took. I will tell you that in cases like this, ultimately getting to the truth requires investigative steps, and that was necessary here. Some of this may play out as the case proceeds, but I don't want to get into that now, particularly given that the case has been.
Did
If
you
there are no further
subpoena the
charges,
speaker?
Do you believe that Jeff Britt acted alone? He did this without anybody in the campaign having knowledge of it?
So Ed, you're asking me a question which is different from what my mission is. Our mission is to determine what admissible evidence we have to charge somebody with a crime. That was the goal of our investigation. It wasn't to engage in speculation. It wasn't to assign responsibility for the conduct of others outside the criminal context. So that was our mission here, and that's what we've done.
Have there been any steps, have there been any investigations into this case before you came in January?
You know, let me put it this way, that when I took over on January 1st, I'm not aware of work being done here in the office. In other words, in this administration, we were working from a fresh slate. Let's put it that way.
Can you explain the rationale behind not charging Ms. Lawton if she was aware of how this all went down?
Yeah, look, I don't want to get into some of the charging decisions that I've made at this point, Steph. I think, again, I think when you're investigating a case, particularly when it is historical in nature, and so what a historical investigation means is it's not proactive, it's not ongoing when the targets of the investigation don't know that it's ongoing. Your ability to gain evidence in some ways that are useful are not available to you. And I can think of cases that we've done in the past. The 3 North Providence town councilors comes to mind, where we had an undercover FBI agent be able to record statements we didn't know we were investigating. When you have to do a historical case, sometimes you have to make choices and decisions along the way. Those things may play out in the context of this case as it goes forward, but I'm not prepared to speak about it.
Can you tell us if you subpoenaed the House Speaker, if you subpoenaed Jeff Britt, and if you subpoenaed the Speaker's Chief of Staff, Leo Skenyon?
Yeah, Kathy, I'm not going to get into the investigative steps that we took, other than to say that I am comfortable that we investigated this case in depth and completely, and I'm comfortable with the charges that we have brought in the indictment today.
Did you feel you had to tread lightly because this involved the Speaker?
No. I like to think my track record demonstrates that I don't tread lightly in any case. And we have a job to do here. It doesn't matter whether you're the person or the target is a member of government or not. We have a job to do. I know the state police looks at every case exactly the same way. If you can't do that, you shouldn't be in this job, frankly.
Has this case opened up any possible further paths of inquiry by your office?
I would say not, Kathy, no.
In general, when you look at this case, I know separating yourself from the charges that were issued, when you just look at sort of what apparently seems to have happened here, what do you think it says about Rhode Island politics and that race in general?
Yeah, I don't know what it says about politics. That's not sort of what I'm focused on in this job as I do the job. I will tell you this. I mean, my takeaway from this, and I alluded to it in my remarks, which is, the Board of Elections really did a good job here, and they did not get a lot of cooperation in a lot of instances as they tried to sort through this. And in many ways, they are performing a function much like ours, where somebody makes a complaint and then they have a duty to investigate it. And when they're not taken seriously, as I think was the case on the part of some people with knowledge of facts that were pertinent to their investigation, A, people should take them seriously, but B, when they don't, then it's incumbent on this office to stand behind the board and make sure that it happens, bringing, as I said, the full weight of this office to that kind of investigation. I think the Board of Elections is doing a terrific job with the resources and the powers they have. But as I said, what concerns me, again, as I reviewed personally the record in this case, was the lack of seriousness with which some people who had knowledge relevant to this investigation with respect to the Board of Elections inquiry. And that's why I think it's important to send a strong message today that when something is referred to us by the Board of Elections, we're going to take a deep dive into it.
Should the Board of Elections be strengthened?
Steve, I don't know. I haven't really given that a lot of thought. I do know this, that we are in position to assist where we need to. And one of the commitments I made upon taking office was to establish a strong relationship with the Board of Elections. I don't think we should be in a situation where they do something for a year and a half or 2 years, reach some level of success and perhaps not complete success and then turn it over to us. I think we have to be speaking on a more regular basis in real time, and we have been doing that. And so I'm confident that going forward, we'll be better positioned to do these cases simply because we'll have more time to do them. I mean, we had to move pretty quickly here given that we took office on January 1st. Well, we got it done, but, having a little bit more time in any case is always a good thing.
You talked about lack of serious...
Are you disappointed at all that this didn't result in charges of other individuals? As we know from the Board of Election investigation, there are a lot of other people around what you were looking at. Are you disappointed that more
Yeah.
people weren't charged?
You know, I don't get disappointed in terms of who we charge, who we don't charge. I will say this, I mean, I think my overall approach to this is that if the Board of Elections reaches a resolution with someone before them, then I'm comfortable with that resolution. That ultimately is their mission in the first instance. So I think it would be the rare case where the Board of Elections reached a resolution that they felt that was appropriate, that I would take additional action. That's not to say I wouldn't, but that would hold weight with me. What concerns me, as I said, in this case, was that a number of individuals in the Board of Elections investigation, at least in the first instance, were not overly cooperative. And I think in that circumstance, and particularly when we get a referral, then we have an obligation to take action where we can.
When you say lack of seriousness, you use that multiple people. Who are the multiple people?
Yeah, well, I think if you go back and frankly look at some of your own reporting, I think you'll see there are some instances where, people were asked to appear before the Board of Elections and then just viewed it as sort of something that they could do if they wanted to do and not do it if they didn't want to do it. Now look, I understand that there may be times when there are legally justifiable reasons not to cooperate with the Board of Elections. People have rights and they should exercise them. But to duck service of a subpoena before the Board of Elections, to avoid service, to simply not return phone calls, to not respond, I think that's a real problem. The Board of Elections is charged in the first instance with ensuring the integrity of our elections, and it's important that people cooperate with them.
Who are you naming other than Britt, who did all of those things, which in his case led to contempt proceedings? Were there other people who you believe did the same thing?
In terms of not being overly cooperative, yeah, I don't want to get into the specific names. I think if you go back and look at the Board of Elections hearings and records, it becomes pretty clear who that is. Again, that's a takeaway that I have from working through this process and making decisions about where we are in this case and where we need to go in the future.
Did Britt cooperate with your investigation?
I don't want to talk about who cooperated or didn't.
Were you aware that Jeff Britt was on a plane today back to Florida? Did you give the okay or anything like that?
Yeah, I'm not going to comment on Mr. Britt's travel plans or whereabouts.
Do you have any other cases from the Board of Elections that you're looking at?
I can't comment on that. I can't comment on that.
Why was he not arrested?
Because we typically don't arrest individuals where there's no flight risk and no danger to the public. That was true when I was in federal service. It's true here. Now, certainly if there's a public safety risk or a significant risk of flight, then we would do that. But I don't believe in arresting someone just for having that arrest moment. He'll be processed, he'll be arraigned, and we'll proceed with the case. He's innocent until proven guilty, and so we brought these charges today. We'll see where it takes us.
When we think of money laundering cases, typically we think of a lot more money involved. So what do you say to people who are going to say, wait a minute, this is a couple of $1,000?
Yeah, like, people will say what they say. We brought the charges that we thought were appropriate.
When did the grand jury actually start? I may have missed that.
Well, the grand jury investigation started after I became Attorney General. I don't want to talk about when specifically, but it started after I became Attorney General.
Could you say when you started taking testimony before the grand jury?
No, Kathy, I couldn't.
Could you say when you first issued subpoenas in connection with the
No, I
grand jury?
couldn't.
Why not?
Just because I think it's important. Look, I'm committed to being as transparent as I can. That's why we're doing this today. But at the same time, the investigative steps that we take, in large part because sometimes people appear before the grand jury and they're witnesses and they don't come into the case in the long run, that to start talking about those things and to give out that kind of information damages their privacy interests in a way that I'm not comfortable with. So a lot of things go into that. And I think there was a benefit to grand jury proceedings that until they are completed, where I think we can do a better job as investigators and as prosecutors, particularly in the course of an investigation where less is known rather than more.
One more question? Time for
I
one
was
more
waiting for
question?
somebody to say that.
Here I am.
Do you have a message for folks in Rhode Island politics who think they can skirt the campaign finance law?
Yeah, look, I don't have a message for people in politics. I think the vast majority of people in politics do the right thing. Again, and I think the Board of Elections, if you look at their history, and I've looked at the history of this case, give people an opportunity to make things right. And I think that's important. I think that's important that they do give people that opportunity, because there are going to be times when The campaign finance laws are not complied with in the first instance, but it's not an intentional act, it's not a knowing act. They're given a chance to straighten it out. I take no issue with that. I do think, though, there are some cases where greater scrutiny is appropriate. I believe at this point this case is one of them, and that's why the charges were brought today.
Can you tell us who's, I know some of the faces, but can you tell us who's standing in back of you as far
I
as
did,
what
so
their
obviously
role?
when you stepped out, you must have missed this.
I did, and I
But, you know,
apologize.
you are such such a veteran of the press corps and a treasure to us here in the state that I'm going to go over it again. I wouldn't do it for Steve Clampton's sake, but I'll do it. With me is Colonel Manny, who I'm sure you know, Captain John Alfred of the State Police, Detective Corporal Anthony Commendatory, who worked on this case, and Investigator Gerard Ratigan used to work in this office as a prosecutor. Back when I was here on my first tour, Gerard's a real veteran. And then Colonel Chief Steve Danvers, who's also a former U.S. attorney, who replaced me back in the day for a short time. And then John Moran, who's a veteran of this office and is chief of our public integrity unit. So John is to the farthest to the right, and Steve is to the immediate right.
Who's prosecuting the case?
Stephen and John. So Colonel Chief Danvers and Public Integrity Unit Chief John Moran. All right, with that, everybody have a great weekend. Again, I apologize for the Friday and the late notice. Thanks very much.